The whole misconduct issue with Fani Willis, it's lately discovered evidence. I mean, this is new evidence, and it really aims at obstruction of justice from the district attorney.
Apparently what happened is Miss Yeager was watching the Fani Willis hearings for disqualification of Fani Willis, and she then came up with evidence that she had accumulated in September of 2023.
This is a very interesting development. I think it's important for me to read the portion of the motion that I think is most appropriate here. And this is what it says. In and around September of 2023, Mr. Bradley was visiting Miss Yeager there in her office when Bradley received a phone call. Miss Yeager could hear that the caller was the district attorney, Fani Willis. District Attorney Willis was calling Mr. Bradley in response to an article that was published about how much money Mr. Wade and his law partners had been paid in this case. Yeager heard the District Attorney Willis tell Mr. Bradley, "They are coming after us." This is a quote. "You don't need to talk to them about anything about us." This goes to the heart of obstruction of justice.
You're supposed to be the district attorney, and you say disclose everything to everybody about all the true developments and what happened. You don't tell them shut up and don't say anything about us unless you've got something to hide or you're concerned about. But what bothers me more than anything, this is coming from a district attorney who is an officer of the court and who is making these statements to a third party.
It could have turned into witness tampering if Yeager had been sworn in. She hadn't been yet. So it right now goes to obstruction of justice.
I think that is correct. So what Fani Willis was anticipating was that Bradley would indeed be a future witness. So the tampering, if you will, hadn't yet occurred because he was not yet a witness. So she was basically saying, keep your mouth shut. Don't tell the truth.
What is relevant right now is that the phone call was received and the DA was focusing on the payments that were being made.
Correct.
And that is what the DA tells Bradley, they're coming after us. You don't need to talk to them about anything about us.
That's very disturbing if true. And I think
by the way, she had the right to pay him.
Judge McAfee said, if he's got a bar card and breathing, you can hire him. I'm not going to look at his his entitlement, his qualifications. But the concern that I have is that you've got an article that appears. It talks about the money that was being paid, and DA Fani Willis tells Mr. Bradley, they're coming after us. You don't need to talk. Of course you need to talk to them about what's going on. You're the district attorney. You shouldn't be telling a witness not to do what justice requires to be done in the case. So if that in fact turned out to be the case, then something needs to be done about it.
So the motion that's pending is to open up, basically, it's a proffer, open up the evidence again. He'll probably let the other side, will let Fani Willis respond, which he needs to, and then set another hearing. So this evidence portion's not closed. This is not hearsay.
Fani Willis is the respondent in the motion. She is present in court and can be cross-examined, and therefore there's an exception to the hearsay rule, and it's an admission of a respondent, and it's admissible. And it's against interest, and it's admissible.
Yeah, so it's admissible. It's not hearsay. That's number one. Number two, with regard to Yeager's responsibility, well, I don't know what took this. Remember, the case only closed out less than a week ago.
Right.
So in this intervening days, I think it was Friday of last week, right? Okay, so today's Tuesday. So this happened immediately. She sees the testimony. You don't know what negotiations were going on between her office and defense lawyers and her Cobb County office. You can't just run into court when you're a lawyer, as Fani Willis did.
I would argue that Ms. Yeager had a responsibility to inform the court that she possessed evidence contrary to the claims made by a witness or a series of witnesses with respect to a public hearing. So Ms. Yeager had no affirmative obligation to contact Judge McAfee until the evidence was adduced in front of the court. And once which was just Friday, and once that evidence was adduced, then I think it would be professional malpractice on the part of the attorneys for the defendants in the election interference case not to attempt to reopen the hearing and reopen the evidence.
That's an important thing what Harry just said. So you put yourself in the lawyer's standpoint, the lawyer that had the information. They need to then go to one of the defense lawyers and say, I possess evidence that is contrary to this. So then the defense lawyers would have to basically question her, find out what that is, and then put it into motion. So I don't think, Jerry, there's a gap of time. It was Friday. She probably contacted them over the weekend. They drafted the motion up and filed it yesterday.
Yeager did what she was supposed to do. She heard testimony that she believed to be untruthful. She went to the defense counsel. She told them about it. They investigated it, and they made their motion. That's what happened in the case. And now it's up to Judge McAfee to decide whether he's going to hear the evidence or not. If, in fact, the evidence turns out to be after Judge McAfee, should he decide to do so, holds a hearing in the case, if the evidence...
You think he will?
Yes, I think he will. I definitely think. Yeah. I don't think he cannot.
Okay.
When you have an allegation, think about this, that the district attorney, not just an officer of the court, which she is, not just a private citizen, but the sworn law enforcement officer, the chief law enforcement officer of Fulton County, when you have an allegation that is from somebody who is themselves a deputy chief assistant DA in Cobb County, right north of Atlanta, heard Willis tell Bradley, quote, they are coming after us. You don't need to talk to them about anything about us. That is obstruction of justice. That is telling...
A felony.
It is a felony. That is telling a citizen who may certainly be a witness, and he turned out to be a witness, don't talk to law enforcement authorities about anything with respect to the money that was being paid to Wade. That is a serious allegation that's got to be fleshed out.
What she's got to be concerned with right now, in my view, is her bar license, committing perjury to the court, that's making false statements under oath, and obstruction of justice. This has become the Fani Willis trial.
Instead of trying the defendants in the case, what has happened is the defense attorneys have very adeptly and adroitly made it a trial of the prosecution, and a prosecutor appears to be liable for many bad acts that they have committed, some of which may indeed be criminal in nature.
I'm concerned about the fair administration of justice here. And when you start getting, it's one thing, lying under oath is bad enough. When you start getting into obstruction of justice, and based on these kind of cases to begin with, I think you're raising an entirely new spectrum of what's at stake here for how we do justice in the United States.
Are they ever going to be held accountable for these bad acts that they've done? And yes, because Fani Willis is the one that's basically under trial right now for her bad acts and criminal actions.
They need to stop this, and they need to close this Fulton County prosecution down. Fani Willis and Wade need to resign. The whole office needs to go. If they need to appoint a new DA, look at the case and then close it.